From the Library of Congress in Washington, D.C.
Good afternoon. I am Ruth LaVouche. I am a senior foreign law specialist with the Global Legal Research Center at the Law Library of Congress. On behalf of the Law Librarian of Congress, Mr. David Mao, I would like to welcome you to the Law Library of Congress and to the 5th annual commemoration of Human Rights Day. Human Rights Day is observed each year to commemorate the adoption of the Universal Declaration of Human Rights, which was pronounced by the United Nations General Assembly on December 10, 1948, following the horrors of the Second World War. Although it is not a binding document, the Universal Declaration of Human Rights has been recognized as having a significant impact on the development of international human rights law, as well as an inspiration to the drafting of various constitutions around the world. We at the Law Library of Congress have an extensive collection of constitutions, of statutory and judicial sources from about 260 jurisdictions around the world, as well as from former colonies and former nations. The vast collection of over 2.8 million bound volumes, as well as access to numerous digital resources from around the world, makes the Law Library of Congress a unique center of research and information in law. This enables researchers at the Global Legal Research Center of the Law Library of Congress to provide research and analysis in foreign, comparative, and international law to the United States Congress, to government agencies, and to the courts. The Law Library of Congress also provides reference services to the public. I would encourage you to visit our website at www.law.gov, where you can find information on various topics. In particular, I would direct you to our comparative law research products, to our Global Legal Monitor publication, and to our In Custodia Legis blog. Before we begin, I would like to thank the Human Rights Law Committee of the Law Library of Congress, and particularly the head of the committee, Connie Johnson, as well as Clifton Brown, standing there, for doing anything I can think of, and also members of the Law Library Reading Room staff for preparing a case with presentation of some relevant resources on this topic. I would especially like to thank Friends of the Law Library for their generosity that made this event possible. Today's panel discussion centers on bioethics and human rights. Modern biotechnological advancements have contributed to extending life, to curing diseases that in the past were considered fatal, and to providing millions of people around the world a better quality of life. These advancements, however, have raised ethical challenges among different communities and nations. In addressing these challenges, we must be aware of the impact of different cultures on bioethical perceptions. The Global Legal Research Center has researched the effects of cultural perceptions and religious beliefs on legislation and practices in foreign countries. You can find several recent reports on this topic on our website, and if you're interested, please contact me after this panel discussion and I can point them out to you. Our distinguished panelists today will address some of the complexities of bioethics in the context of privacy and consent. I will briefly introduce the panelists, and you can read more about them in the program that was distributed to you. The first panelist is Erin Williams. She is a principal health policy advisor with Mitra Corporation. Ms. Williams is an internationally recognized speaker and an author with 18 years of experience in bioethics, health law, and policy. She is currently the Vice President of the International Society of Bioethics Scientific Committee. Ms. Williams' presentation, entitled "What Was That Form I Just Signed?" will present an overview of the current state of informed consent obligations in the United States and set the stage for the presentations that follow. Our second panelist is Gerald Schatz. Mr. Schatz is a former professional staff member of the House Committee on Government Operations. He was a senior staff officer of the National Academy of Science and served as a visiting expert at the National Science Foundation. Mr. Schatz is Vice President of Citizens for Responsible Care and Outreach, an independent educational organization committed to conscionable science and medicine. Mr. Schatz will discuss personal privacy rights in medicine and in biomedical and behavioral research. He argues that these rights are rooted in law and ethics, but too often are ignored. In his opinion, privacy and confidentiality in medicine and research are not dead legally or ethically, but are under substantial challenge, with serious implications for medicine, research, and individual liberty. And last but not least is our own Teresa Papadimitriou, Senior Foreign Law Specialist at the Global Legal Research Center. Ms. Papadimitriou's research work covers the European Union, Greece, Cyprus, and the Council of Europe, with a focus on comparative and international law relating to human rights and international organizations. Ms. Papadimitriou has authored many single and multinational reports for Congress and has served as an expert witness before congressional subcommittees on various topics of expertise. Ms. Papadimitriou will provide us an overview of the regulation of informed consent under the European Union, the Council of Europe, conventions, and other international human rights instruments. She will then focus on the implications of lack of informed consent on forced sterilization of women in Europe. Each panelist will have 15 minutes to address us, and at the end we'll have 15 minutes for questions and answers. Let's begin. Ms. Williams. I think it will be better here.
Is there a clicker or do you just, will someone advance this?
I will let you know.
Okay.
I will have these two, 2
Okay.
minutes before.
Good. If you see me getting the card, you'll know what's happening. Well, I want to start by saying thank you very much. This is a wonderful opportunity, a fabulous venue, such an honor to be back here. For those of you who don't know, until about 1.5 years ago, I worked just down 3 floors with the Congressional Research Service in the fabulous Domestic Social Policy Division. So it is a special treat for me to be back and to see so many familiar and friendly faces. Today, when I first started at CRS, let me tell you, I wrote a tome about informed consent and health protections. This was before I was taught that shorter is actually much better in general and for Congress. So now I'm going to try to condense that tome into a 15-minute talk. Let's see how I do. My presentation today is what was that form I just signed. I do have a PowerPoint, I don't know, but this is not the first slide. I'm not sure.
Oh, I can help you with that.
I will just start to try to keep to the 15 minutes in particular.
Just tell me when to move.
Okay, and I don't mind
Once we find
moving.
it.
Oh, I don't know. Was it loaded on here?
You know what, that's okay. It's probably not meant to be, that's fine. All right, so there are a few main things I want you to walk away with today. One is an understanding of what informed consent and human rights have to do with one another. That's an important point. And I want you to walk away with the second important point of understanding the evolution of informed consent, the idea that it's actually a relatively new concept in our human history. And third, I want you to have an understanding of the basic federal regulations in the US, but the main point of me telling you about those regulations is to try to explain that there are circumstances in which it's possible to conduct research legally in the US without coming across any federal regulations, that there are circumstances in which that could happen. So, what do medical research and human rights have to do with each other? I think there are two primary things that are necessarily involved in medical research that make it inherently a human rights issue. One is that medical research necessarily on people involves risks to people. I mean, if you knew what was going to happen when you tried a drug on someone, operated on someone, did something to them, or you had a pretty good idea, it would not be considered research, right? So there is an inherent risk. On top of that, in most circumstances, there's going to be a power imbalance. That's because somebody who's conducting the research has a lot of knowledge, they have a lot of scientific background and understanding, and the person who is the subject of the experiment, unless you're Jonas Salk and you're experimenting on yourself, but generally speaking, that person is going to have less understanding of what is being tested. So, you have this power imbalance, and the person with less power is the one who is the subject to risk. So there's sort of an inherent issue that, makes it a human rights issue. In addition, there are a lot of kinds of harm that can be caused by medical research, and some of them I think would spring to mind immediately. But there's a sort of a spectrum. On one end, the obvious, there's unethical research. I mean, the Holocaust, for example, which led to the Nuremberg Code, which was the basis of a lot of modern bioethical thinking. There were many examples of people who were captive, being subjected to terrible things in the name of medical science, being submerged in ice water until they died to see what happened. And I think there's universal agreement that that's unethical and questionable whether it's actually medical research, but it was conducted in the name of research. In this country, I mean, we're not immune. There is a well-known case, the Tuskegee syphilis study, which I think we may hear more about. But in a nutshell, that's when African-American men in the rural South were enrolled in, there's some controversy about how it began, but let's say an observational study to watch the progression of syphilis, which isn't a terrible thing in of itself, except that they were kept in the study and not told that they had syphilis, even after it was discovered that penicillin was a cure for syphilis. So the disease was allowed to progress in this population for years after a known treatment was available. So these are examples of harm caused by, I think what is generally, the opinion is that this is just unethical research. This should not happen. There can also be harm that's caused when there is a lack of sufficient research and products go to market. An example of this that's fairly well known as well was when thalidomide was marketed as sort of a miracle anti-nausea drug given to women during pregnancy, a time I can attest when you can be quite nauseous. This happened in the UK, and unfortunately one of the effects of the drug was that it caused birth defects. So, that was a terrible outcome from lack of sufficient research ahead of time. A much more recent example in the United States, the use of pediatric antidepressants, or I guess I should really more correctly say antidepressants in pediatric populations. These are drugs, antidepressants, available and tested on adults that were then prescribed off-label, and I'm not really going to talk, I know there's a recent court case that's pretty exciting about off-label use, but I'm not trying to get into that today, that were then prescribed off-label to pediatric populations, and unfortunately, one of the side effects then, it turned out, that was prevalent in that population was the risk of suicidality. So suicide is really not the outcome you're looking for when you're prescribing an antidepressant. All right, so we have unethical research, we have lack of sufficient research. Also though, sort of moving to the other side, there can be issues with exclusion from research and harms that can be caused when people want to participate. A great example of this was when AIDS first emerged in the population. At the time, it was a terminal disease. There was a lot of stigma involved. It was frightening. And the only option people had to try to get treatment was to be involved in a clinical trial. So instead of wanting to be protected from trials, people were saying, please let me into your trial. Try a drug on me, because that was a chance for survival. And there are also issues that can arise sort of further down the spectrum if there's too much pre-market research before something comes on the market, too many regulations. It can slow down products. And the idea of medical products is generally to help people, that you want to cure them. Not all of them work well. But when you have too much regulation, too many hurdles to go through, you can run into issues with people, especially for life-threatening diseases and conditions. There's also harm caused to people. And there are other things that can happen, like medical tourism, which can happen for a number of reasons, some of them economic, but also if products are available in one place and not another. So I just wanted to sort of set the stage that way to explain more regulation is not always the answer, although certainly a baseline of regulation and having that be followed is a really good approach. All right, I'm going to talk a little bit about the bioethical basis of informed consent. And this is sort of a discussion of paternalism and autonomy. We used to have historically a much more paternalistic approach to medicine in general and research as a part of that. Paternalism, and it's not a terrible thing, it sounds terrible today, but the idea is that the expert knows best, that they can best evaluate the risks and benefits of something, and that they should act in the best interest of their patient or subject. And it used to be the case that physicians were even trained and agreed that they should sometimes be dishonest with patients. If there was information, a cancer diagnosis or something very traumatic that maybe would interfere with the person's ability to heal or to have a good quality of life, it was accepted that it was the physician's role to, turn their attention away from that. And to try to act in their best interest. This is no longer the case in the United States, but it is still the case in some areas of the world. We, however, have moved to a much more autonomy-based society with the idea that the appropriate decision maker in a situation is the individual, that the expert should tell them what they need to know, and that the individual should then make their decisions. And informed consent, the whole idea of informed consent is really rooted in this base of autonomy. I want to note that informed consent is not the only protection for human subjects involved in research in the US, or as some other people would call them, people who volunteer to be research subjects. Also, there are some other mechanisms in place. Institutional Review Board review, and IRB is should be a disinterested group of experts who look at research ahead of time to make sure it's okay. And also there can be institutional assurances of compliance where an institution, the higher ups have to say, yes, we are complying with everything that is necessary. Okay, so informed consent, let's talk a little about what it is. It has two basic components, and those align to the two words in informed consent. One is informed. Here, the idea is that the subject, the person who is going to be the subject, understands what the risks are, all of the relevant information to make a decision. And this should not mean handing them a complicated form with a lot of legalistic stuff and having them sign the bottom. This should actually mean that the person receives the information in language that they can understand without a lot of terms of art, and that it's delivered in a way that they can actually comprehend, informed. And then the second part is consent, and this usually hinges on a person being able to form the state of mind to agree. So usually there are age restrictions, so children can't consent, or you can't be unconscious, you can't have dementia. Well, we can get it, there are fine points, but in general, the idea is that you have the capacity to form this, to say, yes, I want to participate. It often requires documentation, and then the idea is that at the end of it all, that the subject, the person who may or may not participate, has received the information, understands what the risks are inherent to the research as much as they are knowable, and understands what the potential benefits are, and is able to say yes or no, I want to do this or I don't. Okay, so moving into what the current US federal framework is. Again, If I run out of time, bottom line, there's research that is not covered by any of the regulations I'm going to talk about. That's really the point. Right. There are three main sources of regulation in the U.S. regarding regarding human subjects research. One is known as the Common Rule, and this is at 45 CFR 46 subpart A for the law geeks in the house. The Common Rule is called that because it's also been adopted by numerous federal agencies in their own parts of the CFR. So there are really numerous citations. And this is sort of classic protecting human beings, and it has informed consent requirements in it. A very similar set of regulations exists for the Food and Drug Administration, and these are at 21 CFR parts 50 and 56. And I'll get, they are very parallel there are some conflicts, but at the level we're talking, they're very similar. Third is sort of a different kind of thing, which is the Health Insurance Portability and Accountability Act, HIPAA Privacy Rule. And these are designed sort of for a different purpose. This rule is about protecting information and not so much your physical body. And these are at 45 CFR parts 160 and 164. So some of the details. The Common Rule, the trigger for the Common Rule is that you're conducting research that is either funded by or otherwise under the jurisdiction of an agency that has adopted the Common Rule. So if you're doing something and an agency that's adopted the Common Rule is in charge of you or for some, associated with it, you probably need to follow its requirements. For informed consent, it requires that the subjects be given specific information. So, this is research, these are the likely risks, that kind of thing. And that steps need to be taken to reduce coercion. So you can't say, if you don't participate, your doctor won't treat you anymore, that kind of thing. And then ultimately that consent, usually written, has to be given before participating in research. Notice though that, and you can tell from the trigger, sort of the inverse of it, is that the Common Rule does not apply if you are conducting research that is not funded or otherwise basically regulated by a federal agency that has adopted the Common Rule. So the second set of regulations, the FDA, what the informed consent requirements are, specific information given, signed form, that is at this level the same as the Common Rule. The trigger is different. The trigger is that you are conducting some activities in pursuit of getting FDA's approval. And FDA, the Food and Drug Administration, is the gatekeeper for drugs and devices. You need their permission, basically, before you can market them in the United States. So these regulations would not apply if you were doing research and it wasn't in pursuit of something FDA regulates. Now, some interesting things that FDA doesn't regulate, they pretty much regulate nouns. So if you're doing a verb, like instead of a drug, if you're doing surgery or you're doing behavioral research, FDA doesn't have anything to do with that. And so therefore, their regulations would not apply to what you were doing. The third set of regulations, and this again is the completely different beast, HIPAA Privacy Rule. Here, the trigger is that they attach if you are a covered entity, and covered entities are generally speaking like health plans and providers, things like that. And if you're seeking to release PHI, protected health information, this is sort of information that identifies you in some way and has private information, so specific information about patients. What you have to do before you can release PHI is get something called authorization, which is sort of roughly the equivalent of informed consent, but has a different name in this different domain. And just like for informed consent, there's specific information has to be given ahead of time, and you need a written authorization each time information's to be disclosed. There are some times when that authorization is not necessary, specified in the rule, but generally speaking, you'd be outside its scope if you were not a covered entity. So if you're just me, or you're not a health plan, you're not a provider, or if you weren't dealing with PHI, with that protected health information. So, all right, I think I'm doing okay. 2 minutes. So just side by side, a quick recap. You have the purpose of each of these things. For both the Common Rule and FDA, the purpose is the safety of the person participating in the research, like the physical safety. For the Privacy Rule, the main purpose is information, is protecting their information. The mechanism, for the first two, the Common Rule and FDA regs, the mechanism is informed consent. And for the Privacy Rule, it's authorization. And lastly, it applies to, for the Common Rule, federally regulated research. For FDA, research done in hopes of getting a product to market. And for the Privacy Rule, covered entities using PHI. It's worth noting that although these are the three big dogs, I think, in the world of subject protection, there are other laws and sets of regulations that apply, some specific to genetics from the Genetic Information Non-Discrimination Act, some in ARA, some in, having to do with stem cell research, and the list goes on. So there are some specific domains also that have federal rules that apply. And in addition, state and institutional rules may apply. Tort law, for example. If you're walking around during surgery, trying to do surgery on the street side, tort law may apply. You may get into trouble with the police. All right. So the kinds of issues that arise given within the framework of the major informed consent rules that I've described, some of them are individual, like they have to do with individual regulations. Maybe the regulations are such that they lead to really lengthy legalistic forms that basically undermine the point of what you're trying to do. I mean, if you really want to inform someone and get them to consent and think, to be able to think through and consent, if they don't really understand what they're signing, you may be able to check off a box, but you haven't actually achieved informed consent. There can be issues with non-uniform regulations. There are many examples of ways in which the various regulations that are out there may create conflicts or just treat different situations differently. It's not specific to informed consent, but FDA regulations and the Common Rule, at least for a time, treat adverse event reporting differently. So if something happens during the course of a trial, under what circumstances do you need to come back and raise a red flag about that? And there are also some circumstances, and this is the big one, in which no regulations apply. So if you're in a private facility that's not connected with any government agency, so the Common Rule's out, and if you're doing behavioral research, you're putting people in, well, I guess a Skinner box might be a device. You're figuring out whether locking someone in a closet is good behavior modification. I don't know. So FDA is out. And if you're not, and if you're not a covered entity, you're not a hospital or health provider, and you're not trying to share information, then HIPAA Privacy Rule is out. It's conceivable that you could be conducting research that wouldn't be covered by any of those federal regulations. I want to mention that there is a recent development on the Common Rule, the one that all the different agencies have adopted. There's been a lot of thinking about it since it's been around for some time, and there was issued in the Federal Register, Volume 76, Issue 143, starting on page 44512, if anyone is writing it down, that they issued an advance notice of proposed rulemaking, putting it out for comment, looking at all different kinds of areas of the Common Rule, particularly some areas that have been difficult, like behavioral research or like dealing with multi-site trials and the like. So if you're following the issue, I suggest taking a look. And I see that I've gotten the second card, so my time is up. I thank you very much, and I look forward to an animated discussion.
Mr. Schatz, please.
Thank you. May I do this from here?
Yeah, I guess it makes more sense. I should have explained the reason was, and we apologize. I thought that we had the capability of having the PowerPoint, and this is why we are divided here. So in any event, if you agree, we can still put the PowerPoints on, maybe on a later publication of ours to make it clear.
Sure, I agree, yes.
Thank you.
Thank you.
Yes.
I am very grateful to the Library of Congress and the Law Library. I have been grateful for many, many years. When I first went to work for the Congress, my job was saved by help from people in the Law Library and help from people in what was then the Science Policy Research Division. And the library performs a tremendous public service as a disinterested expert analytical service and resource for the conduct of our government. There is no way to underestimate its importance. I also thank the library for this visual aid. This demonstrates the visibility of the processing of your personal data. Now, Ruth mentioned that personal privacy rights yes. I have to go. Oh, I'm being transferred. Oh, okay. All right, have a seat. Okay. We said earlier that personal privacy rights in biomedical and behavioral research are rooted in law and ethics. They are too often ignored, or they are cynically dismissed as irrelevant, perhaps. And the reasons for this you well know. They're ignorance, greed, cynicism, institutional pressures, good intentions, therapeutic illusions, and difficulty of enforcement. But I argue that they are not dead ethically or legally. They are under substantial challenge, and there are implications here for personal liberty. In order to get at this kaleidoscopic topic, we need some definitions in scene setting. Unlike some of the people in bioethics, I'm a lawyer. I have to deal with fact, and rather than what I would like to see. When I speak about privacy, I speak about the right to be let alone. When I speak about confidentiality, I speak about safeguarding the information that we give or has been given to us. When I speak about modern medicine, I'm not talking about doctors alone, but about the panoply of healthcare practice, which involves relationships with people outside the medical and nursing professions. Now, the ethics and law of medicine and research are ancient in many ways and evolving. My mentor was Ed Pellegrino, a gifted physician and educator and scientist. And Ed's view is that medical ethics is grounded in the clinical encounter, as the Hippocratic school tells us. It is for the benefit of the patient. It is dependent on the mutual trust of patient and physician, and you cannot have such a relationship without consent and confidentiality. And indeed, they are universals. The Oath of Hippocrates, the World Medical Association Oath of Geneva call for these precepts. Most interestingly, the new compliance manual of the International Committee of the Red Cross, which deals with medicine in the worst of circumstances, finds the three pillars of health care grounded in medicine and in humanitarian and human rights law: respect for the autonomy and dignity of the individual, maintaining confidentiality, and ensuring genuine and valid consent for any procedure. Now, these precepts are flouted from time to time, but that's rogue behavior. That's not legal medicine, it's not ethical medicine. The Hippocratic requirement of confidentiality is not absolute. The oath says the physician must keep secret that which should not be published. And so there are classic exceptions like bullet wounds, there are urgent public health exigencies, child abuse, and more difficult to deal with the conflicts faced in forensic psychiatry. Overwhelmingly, the ethically consequential fact of American medicine today is that it goes way beyond the examining room and the clinical exchange, the clinical encounter that gave rise to these precepts. It includes actors from outside the medical professional ethical tradition, non-physician researchers, executives, agency administrators, clerks, data miners and aggregators, lawyers, even bioethicists. None of these people has a professional fiduciary duty to the patient. Most of these actors are unknown to the patient or to the research subject and effectively are unaccountable. The culture of healthcare, research, related industry, and their oversight is heavily bureaucratic. Medicine and its cultural surround in this sense are in fundamental tension. Medicine's allegiance is to the patient, to reason case-by-case judgment. Bureaucracy's allegiance is to ostensible efficiency and convenience. For public health operations, public safety trumps within limits. The World Health Organization's 2005 international health regulations defer to human rights, although non-specifically. Medicine requires scientific understanding. Individual genetic information and related pathological information are increasingly important to accurate diagnosis, appropriate therapy, and medicine's technical advance. Now, research and medicine are distinct conceptually, although they often overlap. Unlike medicine, research is not necessarily for the benefit of the individual patient or even for any patient, and much of research is not biomedical. Clinical trials are a relatively small subset of research, and not all research on human beings, not even biomedical research on human subjects, involves direct development of diagnostics and therapeutics. A lot of research is behavioral and social for purposes as varied as health, education, social services, employment, commerce and finance, private and public planning, law enforcement, military and national security concerns, commercial and political marketing, academic advancement, and sales of the data. Some behavioral and social research involves cross-linking with individually identifiable biomedical and behavioral data. A patient's misconception that an experimental intervention is intended to benefit him or her is termed the therapeutic misconception or illusion, even in research intended to treat. The same terms describe, as far as I'm concerned, the notion held by some researchers that some good will come out of what they do. Well, we don't know that. That's why it's called research. Now, humanitarian law, we're still setting the scene here. Humanitarian law involves protection of persons caught up in armed conflict and disasters. Its protective measures are typically ignored in bioethics writing, yet the Geneva Conventions are very firm on privacy and on consent. Human rights law refers to the Universal Declaration as policy. The International Covenant on Civil and Political Rights, which includes a no exceptions prohibition of unconsented experimentation on human beings, and the International Covenant on Economic, Social, and Cultural Rights, which includes a right to health. Human rights law also includes regional human rights instruments. We'll hear more about that. Municipal civil rights and civil liberties law and related enforcement and jurisprudence. Much of the prominent bioethics writing on human rights ignores the Covenant on Civil and Political Rights and its absolute proscription of unconsented experimentation, but invokes the aspirational Covenant on Economic, Social, and Political Rights for its right to health as a rationale for research on human beings, whether or not with their individual consent and whether or not with individual adequate privacy protections. Now, the U.S. law is anything but the European set of values here. We are comparing. The relevant law in the United States reflects privacy and confidentiality as values. In contrast to the EU, for all practical purposes, personal privacy in medicine and research is left largely to medical and researcher conscientiousness, bureaucratic responses to limited purpose statutes and regulations, and the mercies of the marketplace. Here, privacy is grounded in common law with some statutory support in the states and in the Constitution. The relevant torts include intrusion into seclusion, which is invasion of privacy, public disclosures of private facts, and appropriation of name or image for personal advantage. Where state action is involved, the Bill of Rights comes into play. The relevance here to government-sponsored unconsented medical records research is obvious, although what is state action is rarely clear. Otherwise, little remains save the tort law and funding restrictions to deter snooping without judicial warrant. Data miners and aggregators now piece together public records and heedless posts to assemble highly detailed personal portraits. Save for a few limited statutory prescriptions, absent tort law, the privacy invaders in the states are largely free to do what the government must not do. Medical confidentiality gets little special treatment in our law. In court, there remains the patient's limited medical privacy privilege. Within medical practice, the tendency to invoke hypocrisies has been supplanted largely by interim briefings on the so-called HIPAA Privacy Rule. The difficulty is that is in fact a records management rule. It is a regulatory sieve. It leaves the data wide open to government, to law enforcement, and in some cases to researchers. Enforcement lags in security for electronic medical records. The Affordable Care Act invokes medical privacy and confidentiality as important, but it defers to HIPAA. The Genetic Information Non-Discrimination Act provides for individual civil rights remedies in employment cases, but these are very difficult cases to bring where the jurisprudence has largely been based not on individual experiences, but on pattern or practice of invidious discrimination. Human research that is federally funded or in support of applications for FDA marketing approval includes limited confidentiality protections. Agency-specific law restricts what might be allowable under the common rule alone. The Family Educational Rights and Privacy Act and Protection of Pupil Rights Amendment subject Department of Education-funded schools to limitations on intrusive surveys and data disclosures. None of these laws provides an individual remedy. Graham Leach Bliley gives customers of financial institutions, including insurance companies, limited opt-out rights regarding information sharing. The Supreme Court in Sell, United States, put a very high burden on prosecutors for medical treatment of criminal defendants without consent and invoked powerful liberty interests in privacy and personal security. I have seen no account of Sell versus the United States in bioethics writing. For all practical purposes, as patients, as research subjects, with respect to our personal data, we are left on our own. So let's talk very briefly about the threats and the tensions. Within medicine, personal data is shared necessarily for clinical referrals and consultations, including offshore consultations. It is shared for purposes of medical administration and provider reimbursement. Unknown to the patient, it might be shared also for marketing, especially where patients bear their clinical selves to medical and drug websites. Many people do not pay much attention to their computer hygiene. For that reason, providers and insurers who insist on email communication from patients ought to provide for secure communication. Some, perhaps many, medical websites, even those of private practices, may collect personal information for web-based direct-to-consumer behavioral marketing by drug companies. That in turn confounds the doctor-patient relationship. There is a race for data. Genetic information can be very important, but a hospital's blanket requirement of genetic samples upon admission, perhaps on the off chance of clinical need, is not justifiable medically. It's more likely to be for unspecified research. That some genetic information is exploitable only in light of outcome information implies tracking of individuals. In light of research interests, this can have Orwellian implications. So we heard about the ANPRM to rewrite the common rule. Essentially, it guts the common rule. It exempts behavioral research from much ethical scrutiny. We have another initiative within the Department of Homeland Security and contrary to the Organic Act for the department, we have a proposal still pending to allow Homeland Security researchers to web search on individuals without consent. The take-home points. Medicine and public health rest on respect for patients and on good science, which require good data. That in turn requires respectful as well as technically valid personal data acquisition, storage, security, uses, sanctions, access, and remedy. It is not respectful to take a general consent, biosamples, and personal information and admit no further responsibility. Dignity is the core value of the Universal Declaration and the great legal instruments of human rights. We value dignity by recognizing its opposite, indignity. We all know what that is. Freedom from indignity is a matter of right. To many in the world of healthcare, or in the wider world of research and in the economy generally, identity has become a commodity, not so much openly but through deception, contracts of adhesion, or altogether surreptitiously. The costs of identity as commodity are dignity and loss of trust, are loss of dignity and loss of trust between patient and doctor and between researcher and subject. And those costs for me are too high. Thank you very much.
No. I was going to say.
You can steer.
Just be careful.
I'll sue.
Teresa Papadimitriou, please.
Good afternoon, everyone. I'm very happy to be here. I'd like to thank everyone for coming, especially my current and former bosses. I see the three of them here. I'd like to thank also the Law Library for including me in this panel among these two very esteemed panelists. Based on patients' right, informed consent is a critical component, a sine qua non requirement of any medical intervention. The focus of my presentation today is twofold. First, to give you a brief analysis of the legal status of informed consent under the European Union Council of Europe Convention on Biomedicine and Human Rights and other international legal instruments. And secondly, to give you an overview of practice of forced sterilization of women in Europe and means of redress for aggrieved women before international fora. In this context, the judicial response by the European Court of Human Rights to two cases involving forced sterilization of women, I think it's essential and necessary. Since lawyers are fond of definitions, I like to start by defining forced sterilization. It is the procedure by which a woman is subject to a tubal ligation without her knowledge or her informed consent. On the other hand, coerced sterilization is when a woman is induced to agree to such a procedure without her knowledge or her informed consent. And actually, in this case, the second case, in many instances, financial incentives are provided or due to intimidation or threats of losing social benefits. Informed consent, the right of one's own private and family life, and forced sterilization are all interrelated issues, since they involve the right to be secure in one's own person with no interference, and the right to bodily integrity, as was first enunciated by the European Declaration of Human Rights. While men have been subject also to forced sterilization, women have been disproportionately affected. Among women, those who belong to marginalized groups such as Roma women, or those who have mental disabilities, those with HIV virus, and those on drugs are especially targeted. Forced sterilization cases are initially litigated in domestic courts if and when the victims find out that they have been subject to sterilization. Victims may also receive a compensation and an apology, but the damage to their physical integrity is irreparable. From a human rights perspective, sterilization of women without their informed consent is a serious violation of their human rights, especially the right to dignity, the right to privacy, the right to be free of any degrading and ill treatment, and especially the right to reproductive autonomy, which includes the fundamental right to bear not children. Perhaps many of you in this room share the same feelings with me that forced sterilization was a long abandoned practice when states, including Germany under the Nazis, the United States, Brazil, China, Peru, some Scandinavian countries, including Sweden and Finland, practice forced sterilization for eugenic purposes or for birth control mechanisms. And they practiced that at various points in time. The US Supreme Court in 1927 in Buck versus Bell upheld sterilization of a woman in Virginia who allegedly was feeble-minded on the rationale that society, and I quote, can prevent those who are manifestly unfit from continuing their kind. When this case was decided, California had already sterilized close to 20,000 people. It was reported that in 1997, in France, 15,000 of women living in mental institutions were subject to forced sterilization. France is again in the spotlight because of a case that is currently pending before the European Court of Human Rights, and it involves women who were forced sterilized. In June 2011, it was announced in the media that 3 women who were HIV positive were sterilized in Namibia because without their informed consent. The High Court in Namibia ruled that to their favor, but stated that women failed to prove that sterilization was due to their HIV status. Let us examine a little bit informed consent at the EU level, the Council of Europe and other international legal conventions. Although tort law liability for medical treatment without informed consent is still governed by the medical malpractice law of the member states of the European Union, the issue of informed consent also has human rights ramifications under EU law, Council of Europe conventions, and other international instruments. According to these instruments, informed consent is not just an ethical requirement. It is a legal requirement, the absence of which leads to serious violations of human rights for people who are subject to medical intervention without their informed consent. At the European Union level, informed consent appears in two directives. One is the 2001 Directive on Good Clinical Practice during clinical trials on medicinal products for human use. In case of scientific research, the directive requires that the consent of persons participating in the research be written, dated, and signed, taken freely, and after being duly informed as to the benefits and risks involved. The second directive is 9546 EC on the protection of individuals regarding the processing of personal data. By personal data, of course, we mean anything that helps to identify a person. At the EU level, the right to privacy and the right to protection of personal data are two distinct fundamental human rights. Informed consent plays a vital role in the processing of personal data, since such data may not be processed without the consent of the data subject. The Data Protection Directive defines consent as any freely given, specific, and informed indication of the data subject's wishes. A proposed new regulation designed to replace the directive adds one more requirement to the consent, that it must be explicit. In addition, informed consent has a central role in the Convention of Human Rights and Biomedicine adopted under the auspices of the Council of Europe in 1997. The Convention is designed to protect the dignity and identity of all human beings and guarantees everyone the respect of their integrity and other rights. It declares the primacy of the human being and stipulates that the interests and the welfare of the human being shall prevail over the sole interest of society and science. It should be noted, though, that the Convention on Biomedicine has kind of limited effectiveness at the international level because it does not provide an individual the right to instigate proceedings before the European Court of Human Rights. Under the Convention, intervention is a broad term and it covers all kinds of medical actions. The fundamental rule is that any medical intervention may be carried out after the person has given free and informed consent to it. Such a rule reaffirms a person's autonomy vis-à-vis healthcare professionals and moves away from the old and paternalistic, as also Erin mentioned before, that the doctor is the final authority to decide on an issue involving a patient. There are three constituent elements to the definition of consent. It must be given prior to the intervention, it must be free, and it must be informed. These are the minimum requirements established. The consent is free and informed if it is given by an individual after a healthcare professional provided objective information as to the nature of the procedure and possible consequences and risks involved. The information must be clear, exactly similar like in the US law, that it must be clear and it be presented to the individual in a language that he or she understands. And freedom of consent actually has also a twofold meaning. It includes the right to withdraw one's consent at any time and the right not to be informed of the risks associated or whatever about the procedure, but in that case, the medical professional is required to still obtain informed consent. There are some exceptions to this general rule. An intervention can be carried out on a person who does not have the capacity to consent for his direct benefit. In case of minors, the authorization should be given by his parents, representatives, or other person authorized by law. Depending on the age of the minor, his opinion or her opinion should also be sought, and this is in line with the International Convention on the Rights of the Child, which says that children's opinions should be taken under consideration. Cases involving people with mental disabilities raise more complex questions and ethical dilemmas. In such cases, the authorization of the patient representative is necessary. In addition, the wishes of the individual, depending on the severity of his case, of his mental disease, should also be taken under consideration. The second exception is in case of emergency and the appropriate consent cannot be obtained. Finally, when it comes to advanced agreed directives, the Convention takes the approach that these directives should also be taken under consideration. The Convention on the Rights of Persons with Disability, for whom December 3rd is observed as an International Day, requires the consent of people with disabilities to any medical or scientific experimentation. The Convention also affirms the right of all persons with disabilities to marry and found a family based on their free and informed consent. The right of women to decide on the number of children and spacing, including access to information, is guaranteed by the Convention on Elimination of All Forms of Discrimination against Women. The CEDAW committee, which monitors the implementation of the Convention, has emphasized the link between the involuntary sterilization and violation of a woman's reproductive right, and argued that compulsory sterilization violates the right of women to decide on number and spacing of children. The Human Rights Committee, which oversees implementation of the International Convention on Civil and Political Rights, has stated also that sterilization of women without informed consent is a breach of the right to be free from torture and other inhuman and degrading treatment. I'd like to say a few words about the state of forced sterilization of women in Europe. During the communist period, the Czech Republic, Slovakia, and Hungary espoused the policy of sterilization of women as a birth control mechanism. Such policy was applied mainly to Roma women. After the fall of the communists, the practice of sterilization without their informed consent continued in these countries. The rationale was the high and healthy rate of Roma women. The sterilization procedure took place during or shortly after the second cesarean section. In some cases, informed consent was not provided, or in others, it was provided when the woman was in the advanced stages of labor. Intimidation was often used to the effect that Roma women were threatened that they would lose social benefits. It is reported that close to 90,000 women were forcibly sterilized in the former Czechoslovakia. Litigation in domestic courts is the primary tool for aggrieved women to seek redress for medical intervention without their informed consent. This fulfills also the requirement that under international law they have to exhaust their domestic remedies. Litigation, though, is often time-consuming and costly, and in most cases is out of reach for certain segments of the population. Some cases actually are undertaken pro bono. In case of forced sterilization, the main issue in civil proceedings is whether the affected women provided their informed consent to be sterilized. Courts will review all the facts, as usual, and circumstances in the specific case at hand. Governments will use will use consent as a defense and as a way to evade their responsibility. Governments may also have to prove that there was consent that meant all the elements. For instance, that the woman was informed in a clear language appropriate to her level, that the procedure meant that the woman would not be able to conceive, and have children in the future, and that the procedure was irreversible. In addition, courts will look into whether the patient, after being informed of the risks involved, has made a decision, an informed decision, and provided her explicit consent on her own volition. Forcibly sterilized women may bring their cases to the European Court of Human Rights, which is, of course, the court of choice. Other options include filing individual communications with the Human Rights Treaty system, provided the states have ratified the pertinent conventions and protocols. For instance, women may file with the Human Rights Committee of the International Covenant on Civil and Political Rights, under the Convention on the Elimination of Racial Discrimination, or the Convention on the Rights of People with Disabilities, and under the Convention Against Torture. Individual communications may also be filed relating to state parties to the optional protocol to the Convention on Elimination of Discrimination against Women. And I have a case on point. In 2006, the Committee on Elimination of All Forms of Discrimination against Women found Hungary in violation of the Convention on Women. The case involved a Hungarian citizen of Roma ethnicity who in 2001 was sterilized without her informed consent during an emergency cesarean section. She was presented with a paper to sign stating that she agreed to sterilization without giving any clarification as to what the procedure meant. In 2009, Hungary had to compensate the applicant. The European Court of Human Rights has dealt with two cases involving forced sterilization against Slovakia. The first was decided in 2011, and the second was even more recent. It involved a minor and was decided in June 2012. The consent of the mother was not sought in the case of the minor. The facts are very similar in both cases. The applicants were citizens of Slovakia of Roma ethnicity. They were sterilized during the delivery of their second child through a cesarean section. Women were approached by medical personnel while they were in advanced stages of labor and were told to sign a form because if they had more children, either Hui or their children would die. No explanations were offered as to what sterilization meant for their reproductive capacity. Women also admitted that they did not understand fully the meaning of sterilization. The government claimed that sterilization was necessary for health purposes and there was no need to have an informed consent. Of course, the European Court of Human Rights rejected such an argument because sterilization is not a life-threatening situation. In assessing the facts of both cases, the court noted that sterilization without consent of a woman is incompatible with the requirement of respect for human freedom and dignity, and that it interferes with the applicant's physical integrity. The court also noted that sterilization amounted to a major interference with a person's reproductive health status. The court noted that informed consent is a critical component for sterilization as stipulated in the Convention on Biomedicine, which was ratified by Slovakia at that time. As far as Article 2 of the European Convention of Human Rights, which protects the right to life, the court held that in medical malpractice cases, such as the one that was before it, when the infringement of the right to life is not caused intentionally, then the corresponding positive obligation of the state may be satisfied when the legal system provides victims a remedy, either in civil court alone or in conjunction with a remedy in criminal courts. The court held that there was a substantive violation of Article 3, which prohibits inhuman and degrading treatment, and that there was also a violation of their right to respect for their private and family life. The right to private and family life encompasses the right of women to decide freely as to whether and how many children to have, and to determine one's own identity. It found that Slovakia violated the positive obligation under the Convention to ensure that there was in place adequate legislation and to enforce supervision of sterilization practices. These groundbreaking decisions reverberated across the Atlantic. The US Helsinki Commission held a hearing and argued that urged Slovakia to acknowledge and condemn past practices. The chairman of the commission remarked that these cases put a spotlight on a dark and shameful chapter of the 20th century history. Another case is pending before the European Court of Human Rights, and that involves France, as I said before. It was filed in August 2011, and it involves 5 women mentally disabled who sought redress because they were forcibly undergone sterilization without their informed consent during the period of 1995-98. The applicants claim that sterilization without their consent violates their right to be free from torture and ill treatment, the right to respect of one's own private and family life, and the right to found a family. Women in Namibia, Hungary, Slovakia, France, or elsewhere who have been sterilized without their consent share something very profound: the premature ending of their reproductive life. Nothing will change this fact. In 2009, the Czech Republic apologized to women and has expressed its regrets over instances of error. Slovakia is still in a state of denial. Hungary has not expressed any regrets either. It is still possible to perform emergency sterilization on women without their consent. A few final words as to some positive aspects that I see. Publicity of the cases brings the issue to the forefront. As a result, the name and shame approach may induce countries engaged in such practices to discontinue them and to reform legislation and policies if needed. It makes women aware of their rights as patients in general and of their reproductive rights as human beings. Holding governments accountable may also discourage others from engaging in forced sterilization. Finally, in June 2011, the International Federation of Gynecologists and Obstetricians updated the guidelines and adopted some key criteria emerging from cases into its guidelines. Some important highlights include: free consent is a requirement to sterilization. Women with disabilities are the only ones to consent to sterilization. Spouses, parents, or guardians cannot grant their consent. Sterilization for prevention of future pregnancy does not constitute a medical emergency. Consent should not be made as a condition to receive medical care or social benefits, and consent should not be given when a woman is in labor or right after labor. I'm finished. Thank you very much.
Well, thank you all for very thoughtful presentations, and I'll open the floor now for questions. Yes, please.
I'm Donald Barnes from Guangzhou University in China. Informed consent is a very noble idea, and as you has defined it operationally, being presented in terms that the person can understand and so on. I think in practice we're far from that, however. In order to understand the things, some of the medical procedures that are involved, it has taken a doctor 8 years of education to get to the point of understanding it. And in 15 minutes, he's supposed to explain that to a patient. I think that's a little more than is possible. My own experience has been, maybe it's a harsh judgment, is that the informed consent procedures that we have, and for HIPAA and so on, is more for protection of the institution than it is for the protection of the patient. I'd like your comments on that.
Okay, this is working. Thank you very much. That's a particularly insightful comment. It is true that the obligation and therefore the potential risk of not complying with the regulations falls to the institution, and that the potential, as Jerry brought up, as far as being actionable by an individual, there's not a lot there that you can do. It's important to I find it important to keep in mind the ultimate objectives, but I know that in practice, oftentimes we are far from that. It's difficult to distill a lot of information. I would point out that there's no 15-minute limitation in the rule itself, although I know that practically there are often 15-minute limitations in doctor's visits, but not having anything to do with the regulations we're talking about. Would you like to add?
Well, I think the gentleman raised a very important question. As I said in my talk, it is not just a legal, ethical requirement, it's a legal requirement that has to be respected. It doesn't, even if the doctor needs 10 minutes or 15 minutes, I don't think it matters. The whole idea is that doctors need to inform the patient as to the risks and benefits involved. People are not idiots. I believe that all of us can understand if the facts are presented in a language that we can understand, including the cases I mentioned. If the whole issue actually centers on the fact that if the doctors had informed these women what it meant for their bodies, it wouldn't take long for them to understand. So they have to do it. Yes, it is a defense in cases, in medical malpractice cases, I think, which are dealt by the EU member states. Doctors or the governments will use the defense, the informed consent, as a defense. However, from the patient's perspective, the patient can prove that he was given, he granted or she granted the consent, but no explanations were offered. The whole thing was not explained to them in a language that they would understand. And also, in case, for instance, I was reading the fact that if a patient is blind, then the information has to be given either orally, but also in braille, so that the patient would understand what it involves.
Before we move on, if I can take the...
Ruth?
Yes.
Can I
Yes, please.
answer this?
Please.
The foregoing discussion was on medicine. Let me take it into the research realm very briefly. China has signed on to the International Covenant on Civil and Political Rights, arguably, and the no exceptions informed consent provision is customary international law. That seems to be the position of the European Court of Human Rights. And this doesn't mean just paper consent. It means actual informed consent in circumstances conducive to voluntariness. And it seems to me that too often this requirement is ignored.
Yes. Yes? Yes, please.
Hi, I'm Catherine Barrett with Minor. Aaron, I'm sorry I missed your opening remarks, but you may have covered this, but I have a question for you. There's slow, but there's a growing movement in the hospital setting to have actual robots wheeled in to the patient's bedside for information. It's typically done at before the patient is going home, for educating the patient about how to take care of him or herself when she gets home or he gets home. But I can envision a time where that technology would be extended to the information provided to a patient in the informed consent setting, where the robot is reeled in and a lot of information is displayed, for the patient before a procedure, and then perhaps the physician comes in with the actual paper and says, now do you have any questions, and he or she signs it. Have you envisioned anything like that, or do you have any comments around that kind of setup? Does the regulation envision anything like that, or what are your thoughts around that?
Well, there are a few major regulations that might be triggered by that. HIPAA, well, if you're giving the information to the patient themselves, probably HIPAA is not going to be a huge issue. It depends on whether they're putting information back out there and where it could potentially go. The common rule may be triggered depending on who is regulating you, probably in a hospital. The best approach comes from keeping your eye on the prize. I mean, what is the purpose of the regulation? So, I mean, you can envision a world of tomorrow, and maybe it's fabulous because you love robots and you think it's super cool, or maybe you think it's terrible because it's dehumanizing and depersonalizing and we're the human beings. But, you know, if it helps to achieve the objective overall of providing information to people in a way that they can understand, my son, who is now 7, would probably think it would be great to get information from a computer instead of a doctor. Then, there's nothing in the rules themselves I can think of that would necessarily prevent that kind of a technique or an advancement. As to whether it actually achieved the objective of really informing someone and allowing them to make an informed decision, it would really depend on the details and the circumstances.
Emphasize that term, informed decision, because so many people, both in medicine and in research, view the objective as getting the consent. One of the uglier terms is we consent the patient. No, we elicit an informed decision, and we do so. And here, the research regulations and guidance are pretty clear, and so is the Med-Mal law, which is we present neutrally with alternatives. We do not try to persuade, although a physician is in many ways honor-bound if there is a true medical exigency to try to persuade, but at the same time to be fair.
Yeah, I would add to that, I won't be too specific, but in the course of my career I've certainly heard this term consent the person, the subject or the patient. I have also run across situations with researchers saying when I made certain suggestions, but then the person might not agree to do it. Well, if we don't march the soldiers in there with their commander and tell them this is what you're going to do, sign the form, they might not sign and they might not participate. And I think that sort of speaks to the understanding, there's a need for more understanding of what this is and why it's important in the research and medical community. Information is out there, but I think that, education has to be continual.
Any other questions? I actually shared your concern about the level of understanding of the patient, because even if you are provided with a lot of information without going to medical school, residence, etc., you may not fully comprehend, although all of us, or I presume all of us in this room at least, are already Google doctors. I know that myself, I always analyze myself or diagnose myself before I go to the doctor, so that's kind of a risky undertaking. So the question is really not what type of technology, as the second question was, but what this information includes, and what is the ability of the patient to fully comprehend in order to make an informed decision. So if there are no other questions, I would like first of all to applaud all the panelists for a very interesting presentation. And then we would like to invite you for a reception. It's at the end of this room. So please go ahead. Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.